From the bar to the bench, from argument to judgment. In a world where every word matters and every decision echoes. This is Rocket City Bar and Bench. Yeah. Step into the chamber where the truth gets tested, where the facts stand tall and the lies get questioned. Black robes, oak desks, pressure in the air. Every move calculated, every silence a stare. From filings to rulings, from motions to pleas. We decode the system, bring the law to its knees. Not for the chaos, but clarity and light. Where wrong meets consequence and wrong meets right. Precedent matters, every case leaves a trace. Every argument built, every claim we embrace. From the streets to the courts, every voice has a role. We don't just read the law, we expose it, so we break it down. Line by line, no blurred truth, no hidden signs. From the bar where the cases begin, to the bench where the ruling set in. No noise, no spin, just evidence. Welcome to Rocket City Bar and Bench. Cross-examine the facts, put the truth on trial. Every statement dissected, every file compiled. We don't rush judgment, we take our time. Every statute explored, every angle defined. From civil disputes to criminal weight, where freedom is measured and shaped by fate. From contracts signed to rights denied, we bring it forward. Nothing to hide. No loopholes here, no games to play, just real world law in the real world way. We translate the language, make it understood. From legal confusion to something good. So whether you're learning or taking the stand, we put the system back in your hands. Knowledge is power, truth is defense. That's the mission of Bar and Bench. Every ruling has a ripple. Every voice has a place, and every case tells a story that shapes the future we face. We break it down, line by line, no blurred truth, no hidden signs. From the bar where the fight begins, to the bench where the law defends. Stand informed, stay evident strong. Know your rights, know right from wrong. Rocket City where truth makes sense. This is Rocket City Bar and Bench. The record stands. The record stands.
And we are live. Welcome back to Rocket City Bar and Bench, the show where we try to make Alabama law make sense in plain English. I am Carl Weimer, and today, as you will notice, it is just me. My usual two co-hosts, Shay Golden and Michael T. Walt, both had prior obligations and couldn't join me for this episode. But given what's happening in cannabis law right now, this month, and literally this week, I didn't want to push this one back. So you get one lawyer, one microphone, and a full hour of the strangest corner of Alabama law that I know. Off the top, if I look tired, I am. I've been up since 4 a.m. and have been getting up at 4 a.m. If you'll notice, I have up on screen, I got a puppy. His name's Carl, actually. The shelter named him Carl. My name's Carl, so I was like, well, not only is he a really cute puppy, but he's got a great name. But we call him Junior. So in addition to being at work early, I've got to wake up at about 4 a.m. each day to make sure he has time to go outside and eat and do all that stuff. So that's Junior. Junior's been keeping me busy, and it was a long day of work. Moving on, I'm going to go ahead and add something to the screen. Hopefully it's not too small for everybody to see, but these are the references, the Alabama law that I'm going to talk about. So today we're going to do a deep dive on cannabis in Alabama, and I want to be very precise about that word, because cannabis in the state in this state in the summer of 2026 is really three different legal worlds stacked on top of each other. World 1, we have medical cannabis, which now is finally legal and being sold as of about 5 weeks ago. We have World 2, which is recreational marijuana, which is still very much a crime here in the state of Alabama. And then we have World 3, which is the whole parallel universe of hemp-derived products. We're talking your Delta 8, your Delta 9 gummies, the stuff that used to be at every gas station, which lives under a totally separate set of rules that the legislature literally just rewrote. And here's why I refuse to reschedule this episode. The ground is moving under all three of those worlds right now. In April, the federal government partially rescheduled marijuana for the first time in more than 50 years. In June, the United States Supreme Court handed down a unanimous decision on marijuana users and guns. And as I record this in mid-July 2026, a federal hearing on whether to reschedule all marijuana is finally is in its final week in Arlington, Virginia, and is actually going to be heard and wrapped up as of tomorrow, the 15th of July. So, but we'll get into every bit of that. The thread I'm going to keep pulling all hour, though, is consequences. Each of these three worlds was built at a different time by different people reacting to different fears, so they don't all line up. A product that's perfectly legal in one world can be a felony 1 inch over the line in another. And if you're not a U.S. citizen, the stakes jump to a completely different level. I'll illustrate the worst traps with hypotheticals as we go, made up people, real statutes, real numbers. Before we go any further, though, a disclaimer, because I'm a lawyer and I can't help myself. This is an educational conversation. It's not legal advice. Nothing I say creates an attorney-client relationship, and this area of law is moving so fast right now, but by the time you hear this, something may have already changed. If you're actually facing a charge or you're trying to open a business, a marijuana business, you need to talk to a licensed attorney in the state of Alabama about your specific situation. Don't take one guy on a podcast as your legal team, because I'm not, and hold on to this all hour. Even after everything that changed this spring, marijuana is still a federally controlled substance. That matters once for federal criminal exposure, and again, even harder for anyone who isn't a U.S. citizen. All right. So top of the first world, the medical program in Alabama. Because to understand why it took 5 years to buy a single gummy in the state, you really have to understand the law that started it all. So when and how did medical marijuana actually become legal in the state of Alabama? We have to start with the date, May 17, 2021. Governor Kay Ivey signed Senate Bill 46. The official name is a mouthful, but it matters, okay? The Darren Wesley Atto Hall Compassion Act. It's named for the late son of Representative Laura Hall of Huntsville, which is fitting for this show since we're based out of Huntsville, who became an advocate after losing him. And it was carried by Senator Tim Melson, a physician, and Representative Mike Ball. And it lives today in the Alabama Code, Title 20, Chapter 2A, Section 22A1 and following. Now, that wasn't Alabama's first toe in the water. There were two CBD laws before this. We had Carley's Law in 2014, which lives at Section 13A12, 214.2, and Lenny's Law in 2016, which is Section 13A12, 214.3. Here's the distinction that trips people up. Those are affirmative defenses. An affirmative defense is not legalization. It doesn't build a market. There's no license, no dispensary, no place to buy anything. An affirmative defense is a shield you raise after you've already been charged with a crime. You're still arrested, you're still prosecuted. You just get to argue, I qualify under that statute as it not being, a criminal offense, or that you should be immune from it. The Compassion Act in 2021 is the first time Alabama actually said, we will license cultivation, processing, and sales, and protect patients on the front end before anybody gets arrested. That's a huge leap in the state of Alabama. And actually, being not a native Alabamian, I've been here since about 2016. I always thought, particularly after I got out of law school, that Alabama would be absolutely the last state in the union to have anything to do with marijuana, whether that be what happened underneath the Farm Bill in 2018 or medical marijuana for that matter. So here's the thing that jumps out to me every time I read the statute: how hard the legislature worked to say that this is not recreational, right? And if you actually read the enabling statutes, they say very clearly that there is no pathway for recreational marijuana, in the way that it's written. They baked in a constitutional theory right into the findings section, section 22A1. They declare their intent to build, and this is their words, a wholly interstate system. Everything grown, made, tested, and sold inside Alabama. Okay, so it's homegrown in Alabama, I guess you could say. And they invoked the Ninth Amendment and the 1819 Statehood Compact for the state of Alabama. That wholly interstate design was really a federal law dodge, right? When it came to the act that was written in 2021, all marijuana was Schedule 1 under the federally controlled Substances Act, right? And that's the most restricted category. Schedule 1 places marijuana in the same category as heroin. The moment a product crosses a state line, you're in interstate commerce and squarely in federal jurisdiction, right? So wholly interstate was Alabama building the strongest possible argument that this is a purely local matter that the federal government should leave alone. Now the federal picture has changed this April, and I'll walk through exactly how in the criminal segment. But the core point survives. Nothing a state does makes marijuana federally legal, and the interstate design still matters. The act has a business catch too. To hold one of the integrated seed to sale licenses, right, which those are the big money licenses in the state of Alabama, the statute requires the majority of owners to have been Alabama residents for the preceding 15 years. 15 years. That's a long time. And I think it's pretty clear that's a deliberate move. It shrinks the pool of anyone who can apply down to a very small group of established Alabamians. And not only that, but you have to be a very rich Alabamian to afford these licenses and the operating costs, which I'll get into later on through this podcast. But anyway, hold on to that thought because, it'll kind of explode for you in the next segment. Okay, so we'll do a practical example. Say you're a patient. Can you qualify? The conditions are in section 22A3. Roughly 15, 16 categories. Cancer and its treatment for nausea, wasting, and chronic pain. Epilepsy or a condition causing seizures. Crohn's disease, a terminal illness, HIV and AIDS symptoms, persistent nausea that's not pregnancy related. And I should note that if you're pregnant, you're specifically barred from participating in medical marijuana, the medical marijuana program in Alabama. Parkinson's disease, sickle cell anemia, spasticity from ALS, multiple sclerosis, spinal cord injuries, PTSD, Tourette's syndrome, panic disorder, depression, autism spectrum disorder, and the broad one, chronic or intractable pain where the conventional therapy and opioids have failed or are contradicted. Two things patients get wrong, right? Depression and panic disorder are on that list, which surprises people, but general anxiety disorder is not. And a qualifying condition isn't enough on its own. The physician has to certify that you actually tried conventional treatment and it failed or wasn't appropriate. It's a last resort framework, which differentiates Alabama's medical marijuana program from a lot of other state medical marijuana programs. Adult patients must also be at least 19 years old, Alabama's age of majority, and there is a caregiver pathway for minors. So what I mean by that is if you have a minor that qualifies for the medical program in the state of Alabama, you can have a caregiver that's able to go and procure the medical marijuana for the minor. The physician side is really its own regulated world. A doctor can't just recommend. So you can't just go to any doctor in the state of Alabama. These are specific doctors that have qualified. They must register with the State Board of Medical Examiners. They have to take a 4-hour continuing education course, pay a fee up to $300, pass an exam, and re-up those qualifications periodically. They can't even advertise as a cannabis doctor, right? The board limits them to 1 approved sentence. And the doctor and the patient both have to physically be inside the state of Alabama. There's no telemedicine from across state lines, which again is different than other state medical programs. And you need to notice that the word that the statute uses, right? Recommend, not prescribe. That's not a style choice. It's federal law. A doctor writes prescriptions for FDA-approved drugs, and marijuana itself still isn't one, even after this spring's federal rescheduling, which we'll get to. So the whole program is built on physicians recommending and certifying, carefully avoiding the word prescribe, okay, to keep doctors out of the federal crosshairs. Then you're a patient in the registry, or after you've registered, you can get a card after you've seen the doctor, and you pay a fee essentially of $65. Now, the part that's very Alabama, what you can actually buy. This might be the single most important consumer fact in the medical program. No raw flower. You can't smoke it. You can't vape it in the way people are picturing, and no edibles in the candy and cookie sets. What you can buy: tablets, capsules, tinctures, gelatinous cubes. Think of gummies, right? But for some strange reason, they're limited to only peach flavor. We're not in Georgia, we're in Alabama, but peach flavor. Oils, creams, patches, suppositories. If you don't know what a suppository is, you should look that up. And certain liquids for non-combustible inhalers or nebulizers, which if you're not allowed to vape, or it's unclear about vaporization, I still think there's some ambiguity there about, inhalers and nebulizers. The point is, though, supporters said, was to make it feel like a pharmacy product, not a Colorado dispensary, which is kind of ironic because Colorado, if anything, is the golden example of really what recreational rollout looks like, but also medical. We could have looked as Alabama to what a successful implementation of those programs were, taken out the best aspects of the program and mitigated the ones that didn't work so well. But as you'll hear a little bit later on, that's not the way things played out. Critics, the chief being the Marijuana Policy Project, say that banning smoking and vaporization takes away the delivery method that benefits patients the most and increases the cost of each dose. And no bill to expand that menu even got through the 2026 session. Next, let's talk dosing. Section 22A33. The default maximum is 50 milligrams of Delta-9 THC a day. A physician can go up to 75, but only after 90 days of continuous care and only if it's medically appropriate. For a terminally ill patient, you can exceed 75, but there's a huge downside to it, right? If your recommended daily dose goes above 75 milligrams, Section 22A34 automatically suspends your driver's license, whether or not you've ever driven impaired. The dose itself triggers that, okay? That's the state baking an impairment assumption right into the milligram count. For minors, there is a hard ceiling, 3% THC potency, regardless of the carb. On quantity, Section 22A30, a patient can possess up to 70 daily doses at once. So you purchase in increments up to 60. A daily dose is not a fixed milligram number, by the way. It's whatever your physician documents you for in the registry. Next, let's talk money. and the state is making some serious income from this. A 9% gross proceeds tax on retail medical cannabis. 9%. License fees from those that are participating, suppliers in the medical program of $10,000 to $50,000, $50,000, depending on the category, plus an annual privilege tax on the businesses. After regulatory costs, the statute splits the rest. A big chunk goes to the state's general fund, and a meaningful slice goes to medical cannabis research through the state consortium. And here's the part that bites working people: employment, right? The Compassion Act is extremely employer friendly. Notice that I say employer, not patient. It does not require any employer to accommodate medical cannabis. Your employer can still drug test you, still discipline or fire you for a positive test, even with a card, and even if you use it exactly as recommended. It preserves the workers' comp impairment presumption and gives employees no right to sue over a cannabis-related firing. You can be a lawful card-carrying patient and lose your job with no recourse under the statute. So compassion in the title of the act doesn't actually reach your employer. One more consequence nobody puts in the brochure. It's flagged now, and it hit hard a little bit later, right? If you are not a U.S. citizen, even being a registered medical patient can be dangerous. A state legal product used exactly as recommended, card in your wallet, you can still get in trouble. Immigration law is federal, and the Springs rescheduling of marijuana did not fix that. File that away for a second. We'll come back to it. So the laws on the books in 2021. A reasonable listener assumes dispensaries open a year or so after. But if you thought that the state of Alabama was going to be able to implement that quickly, you're very, very wrong. Why did the first store only open 5 weeks ago? In June of 2026, right? Buckle up. This is the part where Alabama made national news for all the wrong reasons. So who decides who gets the license? The Alabama Medical Cannabis Commission, or the AMCC. 14 members. John McMillan has been the executive director through most of this. The statute caps how many licenses exist per category, and those caps are really the prize. Up to 12 cultivator licenses, up to 4 processor licenses, up to 4 dispensary licenses, and a dispensary license can run up to 3 separate locations. The secure transporter and testing lab licenses are not hard capped, so there's no limitation there. And really the crown jewels that I mentioned a little bit earlier, up to 5 integrated facility licenses, okay? 1 integrated facility license lets you cultivate, process, transport, and dispense, seed to sale, and run up to 5 dispensing sites. So 1 license is potentially 5 storefronts plus the entire supply chain behind them. And a state with only 5 available, that is the single most valuable piece of paper in Alabama cannabis. People spend millions of dollars positioning for this. Millions. And with a 15-year residency screen shrinking the field, that small pool has enormous stakes. And that's a litigation recipe. So here's the timeline. The AMCC writes its rules in 2022 and opens up applications. June 12, 2023, the first round, 21 licenses were awarded. And how long did those last? Really just a matter of days. The commission hit pause and rescinded them, citing potential inconsistencies in how those applications were scored. And there were questions about third-party scoring, contractor that made math errors, so they had to redo it. August 10th of 2023, second round, awards to 20 some odd businesses, all were voided too, this time after a lawsuit alleging that the commission violated the Alabama Open Meetings Act. It's worth stopping on that for a second. The Open Meetings Act isn't a cannabis statute, but it's doing a ton of work here. Alabama's Open Meetings Act requires public bodies to deliberate and act in public with notice, with narrow exceptions. if a commission is making literally billion-dollar industry decisions in the way that it looks like it did, it's dodging that. And the courts will unwind that decision regardless of how they feel about marijuana. So basically, long story short is if the courts feel as though you violated the Open Meetings Act, they'll undo what you did. So now we fast forward a little bit further to October 26, 2023. The commission takes an extraordinary step. It votes to rescind everything, all the awards, all the denials, and resets for a third time. A do-over of a do-over of a do-over. And every time it resets, are months where sick patients still can't buy anything, and applicants for these hugely valuable licenses are burning through money with nothing to show for it. In December 2023, they run it again, and this time they award 5 integrateds. But this round plants the seed of the longest running fight for 2 reasons. Procedure. To push the December awards out the door, the commission used an emergency rule. It skipped the ordinary notice and comment rulemaking. And then 2, substance. 1 integrated award went to Truliev's Alabama entity tied to a large multi-state operator, even though the challengers argued it didn't have a top 5 score in that round. Cut a procedural corner and hand a golden ticket to a company critics say shouldn't have placed. And really, that's just fuel for the fire for somebody with a lot of dough and good lawyers. Enter Montgomery County Circuit Judge James Anderson. January of 2024, he issues a temporary restraining order. The cultivator, processor, transporter, and testing lab licenses can issue. The dispensary and integrated licenses are frozen, and they stay frozen one way or the other for well over a year. Then really the best line of the whole saga, the emergency ruling in April of 2025. The plaintiffs, 3 unsuccessful integrated applicants, Gemstone of Alabama, Bragg Canna of Alabama, and INSA Alabama, moved for partial summary judgment, naming the commission and Truliev's Alabama entity. Judge Anderson rules the December 2023 emergency rule void because there was no genuine emergency. Paraphrasing closely, an agency being tangled up in ongoing litigation is simply not a legal emergency. And then the killer, medical cannabis has never been available in Alabama. So its unavailability couldn't be some sudden emergency to justify skipping those normal rules. It's devastating because it's correct administrative law. An emergency rule under Alabama's Administrative Procedures Act requires an immediate danger to public health, safety, or welfare. The court basically said you don't get to invoke the Emergency Powers Act to escape a mess you're in. And a shortage that existed since the beginning of time isn't immediate. So the 5 integrated licenses under that rule, all invalidated. To be fair, the commission's bind was real. Patients were genuinely waiting, and every month of delay was a month a sick person couldn't get product the legislature had promised 3 years earlier. The court's point was just that genuine human urgency and legal emergency under the statute were not the same thing. So, how did they finally begin breaking this logjam? Well, really 2 tracks. On the appeals track, the Alabama Court of Civil Appeals gets involved over the restraining orders, and a 2025 ruling clears the way for what they call investigative hearings. On the trial track, Judge Anderson and the parties land on a mechanism. An administrative law judge, retired Justice Bernard Harwood, is brought in and conducts investigative hearings on the contested categories. And when I say categories, I mean those licenses that were frozen. The denied companies get their day in court. The process gets a record, but the licenses don't issue until all the hearings run their course. One more piece of this fight went to federal and constitutional law, right? The Alabama Always case. Alabama Always is an applicant that kept losing and kept suing. In 2025, it went to the U.S. District Court for the Middle District of Alabama and sued individual commissioners under 42 U.S.C. Section 1983. The federal civil rights statute that lets you sue state officials personally for violating your federal constitutional rights under the color of law. The theory is striking, though. They say that the commissioners retaliated, right? Denied them a license, ignored their grievances because the company publicly criticized the Alabama Medical Cannabis Commission and kept hauling them into court. First Amendment retaliation, speech, and the right to petition, plus the 14th Amendment, due process and equal protection. Those are two extremely important things to consider as, I continue to explain this to you. The company's own people said the quiet part out loud, that some commissioners seem personally offended by the lawsuits. And if you can prove that, it's a serious problem, because punishing someone pursuing you and speaking is close to the core of what the First Amendment forbids a government actor from doing. The big hurdle in any 1983 suit against an individual official is qualified immunity, right? The doctrine shielding officials unless they violated clearly established law. But the point stands. This wasn't a dry licensing dispute. There were allegations the government was playing favorites and settling scores, and it landed in federal court. So where does that all net out as of today? December 11, 2025, the commission approves the dispensary licenses. CCS of Alabama, doing business as Callie's Apothecary, GP6 Wellness, and RJK Holdings. Those licenses formally issue in January of 2026, each after a $40,000 fee. A fourth, Yellowhammer Medical Dispensaries, was approved but held up by litigation and is expected to come online once that resolves. The patient registry opens in April in 2026. And the moment that patients had waited for 5 years, June 3rd, 2026. Callie's Apothecary on Atlanta Highway in Montgomery makes the first legal cannabis sale in Alabama history. The first customer is a patient advocate named Amanda Taylor. Amanda has multiple sclerosis, and she actually had moved to Arizona years earlier to get legal access to cannabis, calling herself a medical refugee, which is kind of funny, but not. And then she came back here to Alabama once the medical program was started to fight for its implementation. She drove 2 hours from Coleman, Alabama that morning, and she walked out with a tincture and a pack of good old peach gel cubes. And then the grand opening followed on June 4th. Let me take a sip here. So now we got to look at the scoreboard, because it shows how early days all of this still is. As of this recording, roughly 9 cultivators, 4 processors, 4 transporters, and 3 dispensary companies are licensed and moving, with more storefronts across the summer in cities like Montgomery, Birmingham, Mobile, Coleman, Athens, Attila, Daphne, Oxford, and Talladega. And I've heard that there also is going to be a storefront open in Owens Crossroads, Alabama. Excuse me. The patient registry is extremely small, though, a few hundred people as of early this summer. The certified physician ranks are equally as thin, with only a few dozen doctors statewide, which really is the bottleneck here. No certified doctor near you means no card for you. So if you're a patient in, say, the Wiregrass or way up in the Shoals, access is still limited. And the 5 integrated crown jewels, well, they're still not issued, still tied up in those administrative hearings. And those are the most valuable licenses in the state. And they're in limbo even as the storefronts are opening. A state audit in early 2026 also flagged an overpayment and, once again, an Open Meetings Act problem. So here's the lawyer's autopsy. Is this a marijuana story or a government process story? 90% a government process story wearing a marijuana costume. Take the cannabis out and you still get the same explosion, right? A brand new agency, a tiny number of licenses worth tens of millions of dollars each, residency moats, as in the people that can even qualify for the licenses, as a shrinking pool, scoring done partly by an outside contractor, and an Open Meetings Act and Administrative Procedure Act with real teeth. You hand that to sophisticated applicants with a lot of money and their lawyers, and every misstep continues to become an injunction. The deeper lesson is pure litigation math. Scarcity plus discretion plus money equals really lawsuits. If you create 5 golden tickets and give a commission broad discretion to pick the winners, the losers will rationally fight to the last appeal because the prize is worth more than the legal fees. The slowness was not a bug in the rule of law. In a strange way, it was the rule of law grinding away exactly as designed, just very, very slowly. Let me plant a flag really at the halfway point because we're about to change gears completely. The first half, we talked about Alabama's medical program under the Compassion Act, a tightly limited, wholly interstate system, no smoking, no flour, peach gummies and pills, 50 milligram daily dose. Your employer can still fire you, and a 5-year licensing war that has finally produced the first legal sale on June 3rd, 2026, with the integrated licenses still stuck in hearings. Everything I just described is the legal world. Step 1 inch outside of it and you're in the criminal code, which in Alabama is not a place you want to be. And this is also where the biggest federal news in 2026 lives. So let's go ahead and cross over. Headline first, right? Recreational marijuana is completely illegal in Alabama. No decriminalization, no small amount for just a ticket like they tried to do in Birmingham. A decriminalization bill, which was Senate Bill 285 from Senator Bobby Singleton, didn't even get a committee hearing in the 2026 session. If you're not a registered patient buying a permitted product from a licensed dispensary, the old criminal law still applies, full stop. And it gets used. By one advocacy count, there was more than 8,500 marijuana possession arrests in Alabama in 2025 alone. That's a lot. The structure of Alabama law, when we're talking about degrees, is a little bit counterintuitive, and they run backward from what your gut might expect. 2 main possession statutes, right? Second degree possession, which lives under section 13A 12214, is actually the lesser offense, possession of marijuana for personal use only. It's a Class A misdemeanor, up to a year in the county jail, not prison, county jail. Fine of up to $6,000. First degree possession, however, the higher offense, section 13A 12213, is way more serious. And you commit it in one of 2 ways. You possess for something other than personal use. The inference really is distribution. Or you possess for personal use, but you've got a prior marijuana possession conviction. And the penalty jump is really a cliff. First degree for other than personal use is a Class C felony. 1 year and 1 day up to 10 years in Alabama prison, right? And a fine of up to $15,000. There's a 2015 reform nuance that the repeat personal use version is generally a Class D felony, 1 year and a day up to 5 years, but it's more probation eligible. But this wasn't for personal use version is your Class C felony, and that's up to 10 years of prison time exposure. So how does a prosecutor decide if it's other than personal use? Well, there's no magic weight written into the possession statutes. It's an inference from circumstantial evidence. Let me make that concrete with our first hypothetical. Let's say you have 2 roommates, Dave and Marcus. Each get pulled over on the same Friday night, and each with exactly 1 ounce of marijuana in the car. Dave has his ounce in a single bag in the glove box, nothing else. Dave is looking at a second degree possession, which is a misdemeanor. Marcus, on the other hand, has his ounce split into 14 small baggies next to a digital scale, $1,200 in small bills, and a phone full of text messages that read like a price list. Same drug, same weight. Marcus is looking at a first degree possession charge, which is a Class C felony, up to 10 years in jail, because everything around the marijuana tells a distribution story. The lesson: in Alabama, the packaging can matter as much as the substance. Now, let me put the federal layer on top, because there are two sovereigns in play here. And this is really where 2026 rewrote the textbook. For over 50 years, all marijuana sat on Schedule 1 of the Federal Controlled Substances Act, the most restricted category, defined as high abuse potential and no accepted medical use, alongside heroin, as I mentioned earlier. That is no longer the full story. Here's the sequence. December 18, 2025, President Trump signs an executive order directing the Attorney General to complete the marijuana rescheduling process, a process that had started under President Biden's administration in 2024, and it had stalled out. April 23rd, 2026, Acting Attorney General Todd Blanche issues the order effective April 28, 2026, when it hit the Federal Register. That moves two specific categories of marijuana from Schedule 1 to Schedule 3. Marijuana is an FDA-approved drug product and marijuana regulated under the state medical marijuana license provisions. The second category includes Alabama's Compassion Act products. Okay, so that's the state medical marijuana license program. So remarkably, the peach gel that Amanda Taylor bought in June is now a Schedule 3 substance under federal law, the same general tier as ketamine, which is not a Schedule 1 substance. Three things to understand about that, and please hear all three. First, it's not legalization. Schedule 3 substances are still federally controlled, regulated, and restricted. Criminal to handle outside the rules. Second, it's partial. Recreational marijuana, unlicensed marijuana, the bag in the glove box that we just talked about, all of that is still Schedule 1 today. Third, it's contested and in motion. Prohibition groups have already sued to undo the order. And the bigger question, whether all marijuana moves to Schedule 3, is being decided right now. And that was what I had mentioned at the beginning of the episode, that it's supposed to wrap tomorrow, July 15th. So whatever really comes out of this is going to reshape this entire episode, and consider this hour really a snapshot that in time. The law literally could change tomorrow. So what does Schedule 3 actually change for Alabama's medical program? Well, research gets a lot easier. Scientists can finally study state legal products instead of only government-grown cannabis. State licensed businesses can register with the DEA. That portal opened on April 29th, and the tax code changed overnight, which is a huge deal. Section 280E of the Internal Revenue Code, which barred marijuana businesses from deducting ordinary business expenses, doesn't apply to Schedule 3. And that's a huge financial break for Alabama's brand new licensees. So what it does not change? Well, it doesn't change Alabama criminal law. Your state charges come from the Alabama Code, and Alabama schedules its own drugs. In fact, a very Alabama footnote, a federal rescheduling automatically flows through to Alabama schedules within 30 days unless the State Committee of Public Health objects. And on May 21st, the committee voted to object. Not to block it, officials say. The state fully intends to make the change, but to buy time and hold a public hearing on its implementation. So even the state law mirror of the federal move is, as of today, paused and pending. Now, this is another big one, firearms piece, because June 2026 gave us a landmark Supreme Court case. Federal law, 18 U.S.C. Section 922G3, makes it a crime for an unlawful user of a controlled substance to possess a gun. And for years, the federal position was that any marijuana user, including state legal medical card holders, were unlawful users. On June 18, 2026, the United States Supreme Court decided that United States versus Hamani, and they decided it unanimously, 9-0 by Justice Gorsuch, Ali Hamani was a Texas man who was prosecuted under that statute based solely on his admission that he had used marijuana about every other day, plus plus he had a legally purchased gun that he kept at home. The court held that the prosecution violated the Second Amendment. And the government can't automatically strip someone of their gun rights just because they regularly use marijuana. But you need to mark the limits on that, right? Their court called its ruling narrow. The statute was not struck down, okay? Other applications like the addicted to prong, think Hunter Biden, and his prosecution for allegedly being addicted to crack and purchasing a firearm, or someone dangerous or actively intoxicated are all still alive. The ATF form you fill out to buy a gun still asks about marijuana, and lying on that form is still a federal felony. So a medical card holder is in meaningfully better shape than they were a month ago. And this is still unsettled territory, not a green light. So do not treat the Hamani case, as card holders can buy guns now. It's just that they said that you can't strip away somebody's right, their Second Amendment rights, if they are a habitual user, I guess, essentially. So anyway, back to the Alabama statutes, because the state penalties are really where most people end up getting hurt. Distribution, which lives in section 13A 12-11, unlawful distribution of a controlled substance. It's a class B felony, 2 to 20 years in prison, okay? Fine of up to $30,000. And distribution is a broad term. There's really actually no money required. Sharing, giving, delivering, all qualify. Hand your buddy a joint, and technically you've delivered a controlled substance. Furnishing it to a minor, which is always a terrible idea. Section 13A 12-15, an adult furnishes to someone under the age of 18, that's a class A felony. In Alabama, class A is 10 years to life in prison. Same class as serious violent crime. Now, the one that generally shocks people, trafficking, because in Alabama, trafficking doesn't mean what it sounds like. Alabama's cannabis trafficking statute lives in section 13A 12-31. Trafficking is triggered by weight alone, okay? So in that particular statute, as it relates to trafficking, weight is the deciding factor. You don't actually have to sell anything. You don't have to intend to sell anything either. Merely possessing the threshold weight, including the weight of any mixture, and you're a trafficker as a matter of law, facing mandatory minimum prison time. There are two tiers: 2.2 pounds, 1 kilogram, up to 100 pounds, mandatory minimum 3 years, and a $25,000 fine. 100 to 500 pounds, 5-year mandatory minimum, $50,000 fine. And then 500 to 1,000, which is 15-year mandatory minimum in prison, and 1,000 pounds or more is life without parole. So, it actually, I had a case when I was still actively practicing criminal law where I represented somebody that had 300 pounds of marijuana and a little bit of cocaine and a significant amount of money. And he was in prison, and we were not successfully able to get that reduced for him because of those minimums. All right, so we should probably do another hypothetical. Hypothetical number 2 is really to show you what the trap is, right? So let's say we have a lady named Tanya. Tanya's cousin leaves a duffel bag at her place for the weekend. Deputies execute a search warrant on the cousin and follow the trail of Tanya's apartment. The duffel bag holds 2.2 pounds of marijuana. Tanya has no record, no scale, no cash, no texts, no evidence that she ever sold anything. If the state can prove she knowingly possessed that bag, she's over the 2.2 pound line, and the statute calls her a trafficker. Mandatory minimum 3 years, and the judge cannot go below it and generally cannot probate it. Intent doesn't save you once you're over the weight. Now, stack the enhancements. Section 13A 12250 adds a mandatory 5 years for sale within 3 miles of a school. And Section 13A 12270 adds another mandatory 5 miles within, or 5 years within 3 miles of a public housing project. Well, if you're in the city, those lines can overlap and you can get an additional 10 years to your life sentence, or potentially a life sentence plus 10, I guess, depending upon what the geography is of where you're getting in trouble. The next trap, and this is a big deal for anybody listening to this that participates in smoking vapes with Delta 8 or Delta 9 or concentrates. And this is, really, it's kind of a sleeper given how the market, I guess, has moved towards vapes and dabs. We'll go to hypothetical, really, number 3, which is, let's say you have 2 college friends, Jake and Ethan. Jake has a gram of marijuana flower in his backpack, personal use, first offense. That's second-degree possession. It's a Class A misdemeanor. Ethan has no flower at all, just 1 THC vape cartridge, which he figures is more discreet and a more responsible choice. Ethan is way worse off. Hashish and THC concentrates, wax, shatter, distillates, the oil in that cartridge aren't treated as marijuana under the 2-degree possession scheme. They're treated as a Schedule 1 controlled substance, and it's a Class D felony. There's no personal use misdemeanor reduction for concentrates. Same campus, same night, same intent. Jake gets a misdemeanor, Ethan gets a felony, because the law categorizes the oil differently than the plant it came from. And paraphernalia, which lives under Section 13A 12260, is its own Class A misdemeanor with felony exposure for selling it to significantly younger people. One bit of good news for defendants over the last decade, though, the driver's license consequence. There was a time simple marijuana possession conviction triggered an automatic 6-month license suspension. Alabama changed that in 2016. Simple first and second degree possession no longer automatically costs you your license. Careful though, that's simple possession. A DUI involving marijuana under Section 32 5A 191 absolutely still carries a suspension. And the multiplier behind every Alabama criminal case, the Habitual Felony Offender Act, Section 13A 59, it says prior felonies of any kind ratchet up the range on a new felony, sometimes to life in prison. So a marijuana felony can be the prior that supercharges your next case, or be supercharged by priors you already have. Now, the part of this episode I want non-citizens to hear, right? Because it's the harshest. Getting tongue-tied and my mouth's dry. And really, it's the least understood corner of this entire subject, which really is it's immigration. And before anyone relaxes because of the rescheduling news, immigration law is key off the Federal Controlled Substances Act. And a Schedule 3 substance is still a controlled substance. Moving marijuana from Schedule 1 to Schedule 3 does not erase a single one of the consequences I'm about to describe. Immigration law does not care what Alabama legalized, and it barely cares what schedule the drug sits on. 2 big buckets. First, deportability. Under the Immigration and Nationality Act, Section 237A2B, almost any conviction for violating a controlled substance law makes a non-citizen deportable. That includes lawful permanent residents, green card holders who've been here for decades. There is exactly one narrow exception, a single offense involving possession for your own use of 30 grams or less of marijuana. That's it. One time, personal use, 30 grams or under. A second possession, any distribution, any trafficking, any concentrate charge, no exception. You're deportable. Second bucket, inadmissibility. Section 212A2. This governs getting in, getting a green card, coming back from a trip abroad. And here's the part that stuns people. You don't even really need a conviction. A simple admission, telling a border officer or a USCIS officer that you've used marijuana can make you inadmissible all by itself. No arrest, no charge, no court. Just saying it. If it's a valid admission of the elements. And it really gets worse. There's a separate ground, reason to believe that you've ever been a drug trafficker that requires no conviction at all and has no 30-gram exception. An officer with reason to believe that you traffic can find you inadmissible on the evidence, full stop. Then naturalization, becoming a citizen requires good moral character. And under the Act, a controlled substance violation beyond that single tiny possession exception generally bars good moral character for the statutory period. A marijuana issue can freeze your path to citizenship for years. All right, let's give another hypothetical. Hypothetical number 4. The one that keeps immigration lawyers up at night. And I really wish Michael was here today because he does quite a bit of immigration law. Let's say we have a lady named Rosa. Rosa is a lawful permanent resident here. She's been in Alabama for 15 years, married to a citizen, kids, has a mortgage, all the stuff. She has multiple sclerosis. She does everything right. She gets certified by a registered physician in the medical cannabis program, gets her Alabama cannabis card, buys her tincture at a licensed dispensary, and stays inside of her documented dose, right? The dose that goes on the registry that's recommended by the physician. 2 years later, she sits down for her naturalization interview, and the officer asks, as they tend to do, whether she has ever used marijuana. Rosa answers honestly and says, yes, I'm a registered medical patient. There's been a formal USCIS guidance in place since 2019 that marijuana conduct can block good moral character even when it's legal under state law. Even working in a state legal industry can do it. Rosa may have just handed the officer a reason to deny her citizenship. Honesty is required, and the consequence of that honesty is brutal. And her Alabama card is really worth nothing in that room. If cannabis touches your life and you're not a citizen, a conviction, an admission, a card, even a job in a legal cannabis industry, well, you need to talk to a criminal defense lawyer and an immigration lawyer quick, fast, and in a hurry, or before you do something that you're going to regret later on. So let's tie this segment together. Does the Alabama medical card really protect you at all? Well, under state law, yes, narrowly. The Compassion Act says that if you're acting in compliance with the Act, your conduct doesn't violate the criminal or drug crimes article, which is Article 5, Chapter 12, Title 13A. Compliance is a state law shield, but it's narrow and it has very hard edges. It only covers you for a permitted form that's bought through a legal channel. It does not legalize flower on the black market for vapes or any other type of black market materials. You have to stay in the possession limit and the documented dose. An out-of-state medical card does nothing in the state of Alabama. There's no reciprocity. And federally, the card sits differently than a year ago. The product is Schedule 3 now, not Schedule 1, but it's still a controlled substance, and there's no federal prescription behind it. And the card still does not reach the immigration court or cross the state line. It's a state law shield against state law charges for specific authorized conduct. It's not a force field by any stretch of the imagination. All right, the through line. Legalization in Alabama is a narrow corridor. Inside it, right product, right channel, right dose, in-state, and a U.S. citizen, you're protected. One step out or one different passport, and the full weight of state and federal law is waiting for you. And nowhere does that corridor get stranger than where we're going next. because the hemp world manages to make some perfectly legal looking products more dangerous than actual marijuana. And the federal picture there flips on its head in November. To understand the gas station THC world, at which you, in the state of Alabama, you used to be able to go and get Delta 8 from the gas station, or they had specific stores that were selling Delta 8. We have to start with the 2018 Farm Bill, right? Officially, the Agriculture Improvement Act of 2018. Congress legalized hemp and critically defined it. Hemp is the cannabis plant and its derivatives containing no more than 0.3% Delta 9 THC on a dry weight basis. And it removed hemp and those derivatives from the Controlled Substances Act. Right there in that definition is the loophole that created the entire industry. Congress measured one specific molecule, Delta 9 THC, in the raw plant, but they were thinking about it from the perspective of regular marijuana, right? They weren't considering what would be done with Delta 8 THC and how it ultimately would be concentrated so that it became an intoxicant. It said nothing about the dozens of other cannabinoids that you can derive or synthesize from legal hemp. And it set the limit on the plant material, not on the finished product. Finished product's total intoxicating punch, as I just mentioned. So entrepreneurs realized take cheap, legal hemp-derived CBD, chemically convert it into Delta 8 THC, which is intoxicating, and argue it's federally legal hemp because it traces to a compliant plant that isn't Delta 9 THC or regular marijuana. The argument had real federal backing. In 2022, the Ninth Circuit, in a case called AK Futures versus Boyd Street Distro, held that hemp-derived Delta 8 falls within the 2018 Farm Bill's definition of hemp. It was a trademark case, but its reasoning supercharged the industry's confidence nationwide. And the DEA, in a 2021 letter written of all places to the Alabama Board of Pharmacy, acknowledged that cannabinoids from one plant at or under the 0.3% Delta 9 threshold meet the hemp definition and aren't controlled. The FDA issued safety warnings but never comprehensively regulated the space. So federally, you had a booming, barely supervised market. Critics in Alabama literally called it the Wild West. How did the state respond? Well, in stages. First, in 2019, Alabama signed its own law with the Farm Bill, took hemp and hemp-derived cannabinoids meeting that 0.3% Delta 9 standard off the state-controlled substances list, and put the Department of Agriculture and Industries in charge of the hemp program. Then Delta 8 exploded. In 2023, Senate Bill 66, effective that August, it put guardrails on psychoactive hemp cannabinoids. No sales under the age of 21, had to be behind the counter, child-resistant packaging, but they were just guardrails. They weren't a ban. And then the earthquake. In 2025, House Bill 445, sponsored by Representative Andy Witt, and in the Senate, Senator Tim Melson, who's the same physician who carried the medical bill. Governor Ivey signed it in May 2025. It creates a whole new chapter for consumable hemp. In Title 28, Chapter 12, Section 28.12.1 and following, and amends the criminal code at Section 13.8.12.214.4. It does have several dramatic, it does several dramatic things at once. The first is really most striking. It bans smokable and inhalable hemp. Raw hemp flower, pre-rolls, hemp cigars, and by most readings, vapes are all prohibited. And it's not just a slap on the wrist. A violation of the smokable hemp ban is a Class C felony now. And we're going to get into some really bizarre results of that implementation. The ban took effect July 1st, 2025, and law enforcement ran seizures at shops around the state in the days right before it. Now, the flagship hypothetical of this episode, the one that captures the paradox this whole segment is really named for. let's say we have two friends, okay, Brian and Kayla, standing outside the same Huntsville gas station on the same evening in 2026. Kayla has a joint of actual marijuana in her purse, real marijuana, federally rooted in Schedule 1, personal use amount, first offense. On the other hand, we have Brian. He has a hemp pre-roll brought perfectly legally across state lines when he went across over to Tennessee, which, as a sidebar, even though I haven't really kept up on the Tennessee implementation, my understanding is that Tennessee is going to restrict much of the Delta 8 allowances that had flourished previously. So Alabamians won't be able to just drive across state lines in Tennessee to get that stuff anymore. 0.3% Delta 9, though, of Brian's hemp pre-roll, and it's federally compliant hemp with the lower THC product by a mile. The thing that legally was able to be purchased in Alabama just about a year earlier. Kayla's exposure is second degree possession of marijuana, which is a Class A misdemeanor, up to a year in county jail. And Brian's exposure under HB 445, smokable hemp ban, is a Class C felony, 1 to 10 years, a fine of up to $15,000. Think about that for a minute. The federally legal, less intoxicating product carries a felony. The federally restricted, more intoxicating product carries a misdemeanor. In Alabama right now, the hemp joint can legally be worse than a marijuana joint. If you designed that on purpose, people would call it satire. So how did we get that? Well, what happens when you regulate a product format rather than by the molecule? The legislature decided smoking anything cannabis shaped was the mischief to stamp out. Partly also was youth access. Partly was also that smokable hemp is indistinguishable from marijuana to an officer on the roadside. But they brought the felony hammer down on the entire format. One practitioner caveat, though, because there is genuine ambiguity. The state's definition of smokable over in section 2812.2 doesn't use the word vape explicitly. It uses broad catch-all language. Some defense lawyers read it to clearly include vapes. Others argue the silence leaves vaping in a gray zone. Until a court or the attorney general settles it, it's only safe to assume is that vapes are covered. Don't bet your freedom on a favorable reading of an ambiguous criminal statute. What HB 445 doesn't do is ban everything. It builds licensed, regulated market for the consumable hemp that survives, gummies, tinctures, beverages, and it hands it to a surprising regulator, the ABC board, the Alcoholic Beverage Control Board, the liquor regulators, now license and oversee consumable hemp manufacturers, wholesalers, and retailers. That full licensing, labeling, and taxation framework switched on January 1st of 2026. There's a 10% excise tax on those items. The potency caps are also very specific now. Whereas you used to be able to go into one of the gas station sections or one of the specific stores and buy bags with hundreds of milligrams, now an edible cannot exceed 10 milligrams of total THC per serving or 40 per container. A beverage is capped at 10 milligrams per serving with limits on the servings per container. And topicals and sublinguals are 40 milligrams per container. Distribution is also locked down. Adults have to be 21 and up only. There's no online sales, no direct-to-consumer delivery, and no drive-through. The ABC board can inspect and seize unlawful product without a warrant, and a retailer has to get the local city council approval before even applying to the state to sell. There's also really the synthetic angle, and I think it's a dagger aimed specifically at Delta. The law prohibits products containing psychoactive cannabinoids created by chemical synthesis. modification, or conversion from another cannabinoid. This is a precise description of how Delta-8 is typically made. It's converted in a lab from CBD. So even setting aside the smokable ban, the converted cannabinoid products that define the Delta-8 boom are squarely targeted. The two-phase rollout, the felony bans in July of 2025, licensing in January 2026, created real confusion about what was legal and when, and a lot of small shops didn't survive. In fact, many larger shops didn't survive. In fact, a lot of places just simply went out of business because they just simply weren't allowed to sell those products. On the preemption question, let me back up for a second. Yeah. So I guess we should go to the courthouse because the industry sued, right? 4 hemp businesses, Mellow Fellow Fund, a Delaware company that ships nationwide, plus 3 Alabama companies, Tasty Haze, the Humble Hemp Shack, and Seedless Green, sued Governor Ivey and Attorney General Marshall in Montgomery County Circuit Court in late June 2025, seeking to block the law before its July 1st effective date. Their theories: the 2018 Farm Bill legalized these hemp derivatives and protects interstate hemp commerce. So Alabama's ban is preempted, plus due process vagueness. The definitions, they argued, are so unclear that you can't tell what's banned. Plus the Commerce Clause and the state constitutional claims. So the court denied the emergency restraining order on June 30th, and the law ultimately took effect on schedule, and HB 445 has been the operative law ever since. There is continuing litigation. On the preemption question, let me give you the honest read because it's mixed, okay? The strongest version of the industry's argument is really about transportation. The Farm Bill really does protect moving lawful hemp across state lines. So a state can't block hemp just passing through. The weak spot is in state possession and sale. Most courts that have looked at this have said that the Farm Bill sets a federal floor, not a ceiling, and expressly preserves states' power to regulate, even prohibit, hemp production and sale within its own borders. So a state banning a smokable hemp product inside the state is on much firmer ground than the industry wants to admit. Transportation is their best shot. And in-state retail bans are really the state's strong ground. So the state's defenders really make a public health case as well. Supporters, Representative Witt, groups like the Alabama Policy Institute, say these products were intoxicating, untested, inconsistently dosed, sometimes made with sketchy chemistry, and sold in a gas station next to the candy with no age check. Their pitch: consumer protection and keeping intoxicants from kids, the same impulse behind regulating alcohol, which is why the ABC board isn't, I guess, a crazy home for it. The industry's counter is equally real. Many products were federally legal and independently lab tested. The felony smokable ban is wildly disproportionate, and the practical effect is to wipe out Alabama businesses and push consumers to the medical program, which is expensive and narrow, or the black market, which is the exact opposite of safety. Birmingham's mayor opposed it on those grounds, and it was really a general clash of values. The legislature was not done, though. In the 2026 session, Senate Bill 1 from Senator April Weaver, a nurse and former federal health official, would have gone much further. Reclassified Delta-8, Delta-10, and the other psychoactive hemp isomers as Schedule I controlled substances at the state level, right alongside heroin, and restricted consumable hemp to pharmacy-only sales with an Alabama-grown seed-to-sale requirement. Essentially near prohibition, which was the reason why I mentioned at the beginning of the episode. I always thought that Alabama would be the ones that were absolutely dead last to implement any type of marijuana. It failed, though SB1 died in the Senate without ever getting a commission hearing before the session ended April 9th. And a similar bill, Senate Bill 321 from Senator Tim Butler, failed too. So for now, HB 445's regulated and restrictive approach is the law of the land, not full prohibition, but pretty close to it. But the votes are clearly there in the legislature, so I suspect they're going to keep trying to push for near, if not total prohibition. Outside the medical program, I should say. Which brings us to the last twist, right? The federal one that scrambles everything again, the so-called hemp cliff. In November 2025, Congress enacted Section 781 of Public Law 11937, tucked into a must-pass appropriations bill, and it rewrites the federal hemp definition top to bottom. 3 changes. 1, instead of measuring only Delta 8 in the plant, the new definition uses total THC, explicitly including THCA, which by itself wipes out the THCA flower workaround. 2, cannabinoids synthesized or converted outside the plant are excluded entirely, aimed straight at Delta 8. And 3, the number that made everyone's jaw drop, finished hemp-derived cannabinoid products are capped at 0.4 of 1 milligram of total THC per container, not per serving, per container. For perspective, Alabama's HB 445 allows an edible 40 milligrams per container. The new federal cap is 1/100th of that, and a single standard 10 milligram gummy is 25 times over that limit by itself. Industry groups estimate roughly 90% or 95%, I should say, of today's hemp-derived cannabinoids products become federally non-compliant, which is why people are calling it a cliff. And it's going to shut down an estimated $28 billion market. $28 billion. So instead of coming up with rules and regulations to allow people to get access to safe, legal products, they're essentially going to kill the whole thing again, and it's going to push everybody to the black market. Unless you're a medical user, and again, you'll have to live with the restrictions of the medical program. So I think, the legislators involved here could be doing a better job. The date on the cliff, though, that I mentioned is November 12th, 2026, which is 4 months from now. Repeal and delay bills have been introduced to Congress, and the industry is lobbying hard. But as of this recording, none of those efforts have advanced. And the working assumption is the deadline hits as written. When it does, anything over that line stops being federal hemp and lands back in the Controlled Substances Act. And note that means alongside the rescheduling story, those products don't fall into the new Schedule 3 medical category. They're not FDA approved, and they're not state licensed medical marijuana. They fall back into Schedule 1. Rescheduling and the hemp cliff run on completely separate statutory tracks. One does not fix the other. At that point, Alabama's 10 milligram framework becomes largely besides the point because the underlying products are federally unlawful regardless of what the state allows. It's important to note there's also an immigration tail on that too, and it is, again, quite the same. Today, a genuinely Farm Bill compliant hemp product isn't a federally controlled substance, so it generally isn't a controlled substance problem for immigration. But after November 12th, a product that exceeds the new total THC limits or a converted Delta 8 product is federal marijuana again. And the moment a product is a controlled substance under federal law, every immigration consequence from the last segment can attach to it. For a non-citizen, it's just gas station hemp or weed was never a great safe harbor. And in 4 months, it may be no safe harbor at all. So again, those that may be here on a visa, you need to be very, very careful about drug use. So let me zoom in and do my best to try and knit these three worlds that I mentioned at the beginning of the episode together. As of July 2026, Alabama has three parallel cannabis regimes, each one of them mid-transformation. World 1, marijuana itself, illegal recreationally under the harsh state criminal code, possession through trafficking by weight, with the federal government holding a hearing this very week on if it's going to be rescheduled. World 2, the medical program, a narrow legal exception, just now operational with pills and peach gummies, 50 milligrams, no flour. Your employer can still fire you if you are a medical patient. And now, remarkably, Schedule 3 under federal law, with Alabama's own state schedule response pause for public hearing. And then we have World 3, which is hemp-derived THC, governed not by the cannabis statutes at all, but by a hemp chapter of the liquor board in Alabama, where smokable forms are a state felony, edibles are capped and taxed, Delta 8 is squeezed, and a federal cliff in November may flatten most of what's left. The paradoxes between the worlds are the whole point. A patient can hold a legal gummy that would be a crime without the card. Brian from earlier, the hypothetical that I gave, Brian's federally legal hemp pre-roll is a state felony, while Kayla's marijuana joint is a misdemeanor. Ethan's vape cartridge is a felony, while Jake's flower is not. Tanya never sold a thing out of that duffel bag, and she faces a mandatory minimum sentence. Rosa followed every rule Alabama wrote and still can't safely answer the question at her citizenship interview. None of it lines up because each world, as I mentioned at the beginning of the show, was built at a different time by different people, all reacting to different fears. Okay. So to not reason by analogy across these worlds, it's basically legal weed or it's just hemp. It's exactly the intuition that gets somebody a felony now. Or if you're not a citizen, it's a one-way ticket out of the country. Each product, each format, each channel sits under its own rule in two different legal systems, state and federal. And the rule you want it to be under is not the rule it's actually. Practical bottom lines, and then I'll let you go. If you're a patient, the program is real now, but small. Limited doctors, limited stores, limited product. Get certified through a registered physician, get your card, buy only from a licensed dispensary, stay inside your documented dose, and know that your card stops at state lines and doesn't bind your employer, okay? If you're looking at hemp products, assume that anything smokable or inhalable is a felony in Alabama right now. Watch the potency caps. Buy only from an ABC licensed retailer. And circle November 12th on your calendar because the federal ground rules change that day. If you are not a citizen of the United States, green card, visa, any status, treat all three of these worlds as radioactive. Okay, danger. A conviction in most cases, or even a mere admission, a medical card, or even a job in a legal marijuana industry can cost you. And neither Alabama's card nor the Springs federal rescheduling fixes that. So talk to a criminal defense lawyer and immigration lawyer before you act, whether that be if you are using or if you got a job in a medical marijuana business. And for everyone, I want you to watch these dates. July 15th, the federal rescheduling hearing wraps up. That's tomorrow. And we'll learn whether all marijuana is headed to Schedule 3. Then we have November 12th, which is the hemp cliff that I just got done talking about. And whenever Alabama's Public Health Committee finishes its hearing on the federal rescheduling, we don't know that particular date yet, but any one of those could rewrite a chunk of this episode. And when they do, I will cover it. hopefully next time with Shay and Michael here, because they're both brilliant guys. And, I would have liked to have been able to do this, but as I mentioned before, I didn't want to have to rewrite the whole episode tomorrow if everything changed. So everything I cited today, every statute, every section, every case, will be in the show notes that I'm going to post, so you can read the actual language for yourself. The actual language is what controls, not my summary of it. Okay, so just make sure you're doing your research. And last reminder for the people sitting in the back, again, this was an educational conversation. This is not legal advice. Cannabis is in most forms still restricted under federal law. If you've got a real problem or a real plan, whether that be you're in trouble or you want to open a marijuana business, you need to talk to a qualified Alabama licensed lawyer about your facts and circumstances. One last piece, and I guess that this is an appeal to everybody out there, okay? If you're using marijuana of any type, particularly now that the medical cannabis program has been implemented, you need to make sure that you're staying safe and you're staying inside the rules. And those that may be out there listening to this, if you're buying, vapes, Delta 8 vapes across state lines and bringing them back to Alabama and using them, it's a quick, fast way to get a felony. So, know what's going on. And if you need to re-listen to this episode, please do so. But it's serious business, and everybody needs to be informed about what's going on. So I think that's it. Yeah, that's it. So anyway, for Rocket City Bar and Bench, I'm Carl Weimer, again, flying solo this week. And thanks for spending, I guess, a little over an hour with me. Hopefully you found it informative, and stay safe, stay informed, and I'll see you next time.